And they specifically say in that memo that going forward, it should not be enough just for a naturalization applicant to show they have no criminal history. They also want to see positive equities.
Even an email is evidence, can be used as evidence of your good moral character.
Welcome to Statutes of Liberty, an immigration podcast brought to you by Klasko Immigration Law Partners. Join us as we unravel the ins and outs of immigration policy, from the issues of today to the historic basis for laws already in place.
Hi, everyone. Welcome to our second episode on naturalization. My name is Karuna Simbeck. I'm a partner here at the firm. I'm joined by my colleagues, Stacy and Megan Kludt, to talk a little bit more on naturalizations. So in our last episode, we talked about who qualifies for naturalization and how the process works. Today, we're focusing on the issues that often surprise applicants, the things that can delay an application, lead to a denial, or even in some cases, create immigration problems that didn't exist before filing. So, Megan, let me ask you, people often assume that once they're eligible for filing, it's just a formality. Is that always true?
No. Once you're eligible for filing naturalization, well, first of all, it is a big question whether somebody is eligible. And just because they got their green card 5 years ago, it doesn't necessarily mean that they are ready to move on to naturalization. We need to take a close look at what they've been up to in the 5-year period preceding the naturalization application. And this is a statutory 5-year period. In some cases where someone is married to a U.S. citizen, that might be a 3-year period, but this is a special look back period. So if certain criminal activity has occurred or other issues that might implicate somebody's moral character, the naturalization could be denied. So as an attorney, you want to take a very careful look at everything they've been doing in that period of time, anything that could imply that they don't have good moral character, anything criminal. And that is true all the way up until the interview and also at the oath ceremony. So once you've had your interview, that's usually not the end of your naturalization journey. You usually have to wait some period of time before you take the actual oath, and you do have to remain eligible up until then. I could talk a little bit about the criminal issues that might come up. And one thing to keep in mind is after someone has a green card, lawful permanent resident status, they can still lose that status by committing certain crimes. And that can be an issue because sometimes you might have a client that has been convicted of a certain crime, and if it is brought to USCIS's attention, there is a risk, sometimes stronger, sometimes less, that they will be subject to removal. And they might actually get called back in front of an immigration judge to try to explain why they shouldn't actually lose their green card. So sometimes we say, it's not a good idea for you to pursue naturalization because you will trigger this inquiry now into whether your green card should even still be allowed to stand. Some of the things that can come up that would trigger removability are crimes, as they call them, crimes involving moral turpitude. So certain kinds of crimes that are considered to be, to show that someone is, inherently vile, base. They're doing something that shows that they're a bad person, essentially. If you have a certain number of crimes like that, that could result in your naturalization being denied and also potentially your green card being challenged. Almost any crime involving controlled substances, they will be a huge issue, both for naturalization and your green card. If they find you should not have been granted adjustment of status, your green card in the first place because of a criminal issue, that could come back to bite you. Also, certain firearms offenses are problematic, and domestic violence crimes. So that includes stalking crimes and harassment crimes, violation of restraining orders. Those kinds of things could come up and be an issue when you're trying to apply for naturalization. At the end of it, Yeah, there is a determination as to whether you have good moral character, and there are certain kinds of crimes that are considered to make you definitely ineligible for a good moral character finding. So if you're an attorney, you want to look at INA section 101 subsection F, because they have a list of things where if you have one of these things, it's not even discretionary. They actually cannot find you that you have good moral character. So, for example, if during the statutory period you were incarcerated for more than 180 days total, whether it's state, federal, combined, you cannot show that you have good moral character. If you are a habitual drunkard, you cannot show that you have good moral character. A smuggler, if you derive most of your income from gambling. So there's a list of things to look up. And then aside from those things, there are also just really anything that shows bad moral character, such as not paying your taxes, things like that. False testimony is a big issue. So if they find that you lied at any point to try to achieve an immigration benefit, that could be a bar to your naturalization, even if the thing you lied about was not actually relevant to your eligibility to the benefit. If they believe that you intentionally lied about something because you thought it would help you in an immigration case, that could be a problem. Unlawfully voting or even unlawfully registering to vote could be a major issue for your naturalization. If you believe you may have accidentally registered to vote, it's a good idea to try to do whatever you can to reverse that, to let the voting rolls know that you shouldn't be on there. You shouldn't lose your opportunity if you accidentally ended up on a voter list, but this is something that will be a really big issue, and it's really hard to fight. Other things like DUIs are a problem. You said failure to pay child support, things like that.
So, Megan, you mentioned that, some of these issues, including criminal issues, can impact your ability to naturalize. What happens if some of these issues occurred even before you applied for your green card and you disclose that information in your green card? Is that something you need to disclose in your naturalization application again? Is that something you have to worry about again during the naturalization application process?
In the naturalization process, this is really the government's last chance to fully look at your situation and your history. There are certain kinds of criminal issues that could be problematic, even if they happen before the statutory period. For example, maybe you had one DUI before the statutory period, before you got your green card, and now in the statutory period, you got two more. And maybe USAS they're not so much looking at the first DUI, but they're saying, these other two that you got were subsequent. So this was something you were doing after already having a history of having done it. So we're not specifically looking at the first crime, but it makes the second crime worse. So you do want to disclose all of that. And also, there could have been an error. They could go back and say, we think that the green card application should have been denied based on this. So the entire criminal history is always going to be relevant. So it's good to do a full analysis. Is this going to result in me losing my naturalization case? Maybe not, but I still want to fully disclose it.
Yeah, and that's why it's really important to go back and look at the immigration history, right? What's been provided previously. So many times we have consults over working on cases, and the client says, "I forgot to mention that I had this issue previously. What should I do? Should I disclose it now?" So looking back at immigration history and making sure you're disclosing all of the relevant information to your attorney during this process is just really important.
Absolutely. And with false testimony, they could go back and say, "Hey, you had this minor criminal issue. It would not have stopped you from getting the green card, but since you deliberately concealed it on your green card application, we think that you've committed false testimony. That could be a problem for your naturalization application." So you want to look back at the whole immigration history and also what information was provided on the green card application to make sure it all lines up.
You mentioned, good moral character, and that's just something we've been hearing more and more lately. Is this something new? Has it always existed?
So, absolutely, the good moral character requirement has always existed. But there's a discretionary component to some of it. I read off some things that will definitely bar good moral character, but there's also a component of the officer looking at the big picture of the case and deciding, okay, is this someone that should be barred for good moral character? Maybe it's not mandatory, but in my personal judgment, I think that we have a character issue. So that has always been a part of a naturalization case. But in practice, usually you could establish good moral character by showing the absence of bad moral character. So I've paid my taxes. I don't owe any child support. I have no criminal record. And that's enough. You have nothing to go after me for. So the question is there something new going on? In August of 2025, the Trump administration did issue a new memo discussing good moral character in the context of naturalization applications and emphasized that this really needs to be a holistic analysis that balances the positive factors that someone has versus the negative factors. And they specifically say in that memo that going forward, it should not be enough just for a naturalization applicant to show they have no criminal history. They also want to see positive equities. So the memo mentions evidence of sustained community involvement, family caregiving, your education levels. Do you have stable employment? Have you had achievements professionally? How long have you been a green card holder? And have you complied with all of your obligations as far as taxes and other financial obligations? So this is a new concept. So far, I don't think we've heard about anything drastically changing in practice in the interviews, but this memo came out. So we may start to see that still in the future. And, we all have to decide how we're going to respond to this new memo and the change.
Yeah. And so just to take a step back, so the policy, good moral character has always existed. You have, you didn't previously have to show positive factors, but now you do, even if you don't have any crimes, you don't have any underlying issues. The policy memo says you still have to show good moral character. So, Stacy, can you tell us a little bit about, how can someone document good moral character?
Sure. Thank you, Karuna. So, if you are a mentor, get a letter from your mentee or from the organization that you're mentoring for. If you've made charitable contributions, you can print out copies of the receipts. If you're a good neighbor, if you shoveled your neighbor's walk when it snowed, you can get an affidavit from that individual. And if you volunteer at your kid's school, or if you go to a church or a temple or a synagogue, maybe getting a letter from the religious person who can attest that you're a member of good standing, or that you assist with events or help elderly people find seats, whatever it is. You can get affidavits from friends, family, neighbors. You can get certificates if you have completed, and whether it's an advanced degree or maybe it's just an appreciation certificate from a school or an organization. Maybe your employer has a program where you can volunteer. Even an email is can be used as evidence of your good moral character.
Thanks, Stacy. We've spent some time discussing the reason someone might not qualify for naturalization or the issues USCIS closely examines. But there are also circumstances where the law recognizes that certain requirements simply aren't possible for everyone to meet. So, Megan, let's shift gears and talk about waivers and exemptions that are available.
Yeah. So one of them is a medical disability. And what this really comes down to is, can everyone actually attend the interview and go through that process of sitting down with an officer, completing the English and civics test? And also, are they able to take the oath of allegiance? And some people struggle with this. Somebody may, for example, have been diagnosed with Alzheimer's or dementia, and they just are unable to remember new facts at this point. So there is a waiver that can be filed on Form N-648. And the tricky thing with this is they often get rejected if they're not thorough and complete and really explain the issue. So first of all, you have to have somebody sign this form that is experienced in diagnosing these disorders. Whatever the diagnosis is, they must be somebody that has experience in this. They have to be able to explain exactly what the mental impairment is or the developmental disability. And it has to be something that will be ongoing for at least 12 months. And where I've seen pushback on these, it's usually because they say that the medical professional did not explain completely why the dementia that the person has prevented them from learning um, the questions on the civics test. So there also has to be a strong connection between the two. An officer is not allowed to, second guess a medical professional's opinion, but they can push back and say, this opinion doesn't explicitly say why this person is not able to learn any English. There are certain age exceptions for how long you've been in the United States and your age. Stacy, did you want to mention that?
Sure. So if you need an exemption from the English language requirement, if you're 50 years old and you've been a green card holder for at least 20 years, or if you're 55 years old and you've been a green card holder for at least 15 years, you're exempt from the English language requirement, but you're still required to take the civics test. You can take the civics test in your native language, but you also need to bring an interpreter, and that interpreter needs to be fluent in both the English language and your native language. There is also, if you're 65, there's an exception for if you're 65 or older and you've been a permanent resident for at least 20 years, you'll be given special consideration if you're unable to take the civics test.
And there are some occasions where maybe you don't meet those specific exemptions, but you need accommodations. So there can be a middle ground. For example, some applicants maybe are unable to just get to the field office, so they can have an off-site examination somewhere else. Some people may need to communicate non-verbally, so there can be specific exemptions around that. Some people might need to have somebody with them at the interview, whether it's for mental health reasons, just to calm them or help them in other ways. And also, if somebody's deaf or hard of hearing, there are special accommodations around that. So you may not be eligible for a full exemption of one of the requirements, but they may be able to accommodate your needs, whether it be for the interview or the oath ceremony.
And one additional reasonable accommodation is extended time. In schools, a lot of us have kids who have 504s for extended time to take the test. Well, you can request that, but you want to make sure you make your reasonable accommodation request ahead of time so that USCIS can accommodate.
Yes, and that's a good point. The same with the medical disability. You want to file that N-648 waiver form with your N-400 if you can, unless something has arisen while the application was pending.
Right. If you can show extenuating circumstances, maybe there's a new condition that arose from the time that you filed and before your interview, or maybe the condition that you had before your interview has been exacerbated and gotten worse and impacts your ability to take one of those English or civics tests.
Yeah, and like you both said, this has to come from a medical professional. So it's not just enough that a family member is attesting to this. This actually needs to be from a medical practitioner and hopefully someone who has been treating the applicant for these conditions so that they can attest to this information. Speaking of accommodations, Megan, can you tell us a little bit more about, someone who has religious or personal objections to bearing arms? How does that impact the naturalization process?
Yeah, thank you. So the part of the naturalization process requires the swearing of an oath and making certain promises to the US. And one of them is that you will bear arms on behalf of the United States when required by the law, and perform non-combatant services in the US Armed Forces when required by law. So there is an exemption to this if you have a religious opposition to it, your religious beliefs or conscientious objections to it. So this, you can show your involvement in your faith. You can get a letter from your church, but the most important thing is your own personal statement explaining this, explaining where it comes from. I had a case with a client who did request this exemption, and he had gotten his green card in very difficult circumstances. He had some fairly serious criminal issues. We were in the immigration court fighting those out, and ultimately the judge decided his crimes were not serious enough and gave him a second chance, and he was able to have his green card. And since then, my client became very involved in the church. He actually had already been doing so while he was in prison. And by the time I met him, he was very serious about his faith. And he said, it's just against my beliefs and my faith to actually use a weapon to kill anyone. And I will do other things. I'm happy to perform non-combatant services. And so he wrote a letter explaining exactly what his relationship and journey with God had been, why he was there, why he developed the beliefs he had, his relationship with his religious community, and the basis for his beliefs. And, he did have to explain this also at his interview. And it is on the officer to really inquire about this and to understand the basis for the objection and make sure that it makes sense and it's for the right reasons. But in our case, he was granted an exemption without any issue. And that's actually the first time it had ever come up for me. So it was a nice experience. But it can
Yeah,
be.
and I can't say if I've ever had to deal with this issue. And so, we want to advise clients if this is something you're serious about, you absolutely need to be prepared to explain the whys. And it will ultimately be the discretion of the officer to agree with that or not. In our previous episode, we spent some time talking about physical presence and continuous residence. Many of our listeners work for multinational companies or spend significant time abroad. So, Stacy, can you tell us how do overseas assignments affect someone's eligibility to naturalize?
Sure, thank you. So, overseas assignments can cause complications for both physical presence and continuity of residence. Any single trip that's outside the United States for 6 months or more, but less than a year, there's a rebuttable presumption that you've broken the continuity of your residence. If you remain outside for more than a year, then it's evident that you've broken it, and it resets your naturalization clock. But if you know ahead of time that you're going to be out of the country for an extended period of time, you can apply for a reentry permit. Typically, you only need the reentry permit if you're going to be out for a year or more, but it's still advisable if you're going to be out even between 6 months and a year, it's still advisable to get the reentry permit. There is a provision called 319B in the INA that allows certain spouses of U.S. citizens who are working abroad to obtain citizenship on an expedited basis, bypassing the physical presence and residence requirements. So you have to intend to join your spouse abroad, the one that's working for a qualifying entity, and that it could be the U.S. government. It could be a U.S. institution of research or a U.S. corporation engaged in foreign trade or commerce. And so you have to be in the United States at the time that you have your naturalization interview, do your testing and your oath. And you also have to intend to leave the country to join your spouse within a few weeks of getting your naturalization. Um, and you still have to take the tests, the English and the civics tests. And you still need to show good moral character for the past 3 years.
I know we had a situation recently where, the applicant was with their spouse outside of the U.S. because the U.S. citizen spouse was working with one of these qualifying entities, and the biometrics became a huge problem because they weren't able to return. There were just lots of different circumstances that were impacting their ability to attend the biometrics in the U.S. And so it took some coordinating, but they were able to attend the biometrics in a different country. And those biometrics were taken at a consulate because not all countries have a USCIS office. And so once those biometrics were captured at the consulate, they were actually sent here to the US and then submitted to USCIS. So, there are things you need to consider, and it does require some planning. Stacey, we've heard that if you are married to a US citizen, that you can apply for naturalization in 3 years. Is it really as simple as just being married for 3 years, or are there additional requirements?
So there are a few requirements. You must have lived in marital union with that U.S. citizen for 3 years, the 3 years that you're using to qualify you. There are some exceptions to that. You would have to show that maybe your spouse is on military orders and that's why you're not living together, or maybe a job relocation, but you really have to be able to document that. That's the reason that you are not living together. There's also an exception if, there's military service. I don't know if I mentioned that. So the U.S. citizen spouse must have been a U.S. citizen for those 3 years that you're using to qualify. So if your spouse was a permanent resident and then became a U.S. citizen, that doesn't allow you to apply in the 3 years if they were not a U.S. citizen for the full 3 years. You still have to show physical presence. That's 18 months. And you still are not supposed to have broken the continuity of your residence, meaning that you should not have left the U.S. for a year or more. And you still have to fulfill 3 years of the good moral character and pass the English and civics tests.
I will just add that the requirement for someone to be living in marital union can be a little bit tricky. I did have one client once. It was a couple that was in their 60s, and we were about to file the 3-year naturalization. We were close to the 3 years, and the U.S. citizen husband had a serious stroke, and then he was confined to an institution that he wasn't able to leave, and they were not actually able to live in marital union at that point. And I didn't see an obvious exception around that, so we did end up waiting the full 5 years rather than go through the application and have them find that they were not living together, and that would be a bar for the application. So he was unable to come to the house. She would of course visit him, but didn't stay where he was. And then unfortunately, right before we got to the 5 years, he also passed. So these can be really tricky situations, and your clients might have unusual living situations, but just know there are only certain exemptions around that. So if you do have a situation around that, you want to talk to your lawyer about it, or make sure as a lawyer, you've talked to your client about it.
Yeah, and like you said, Megan, some of these are sticky situations. There's no obvious answer. And so when there's no obvious answer, it really does come down to what's going on at that particular USCIS field office that's going to adjudicate your case. Because we've seen different offices take different positions. So you might be one of those who gets lucky if you can show that, you were in marital union, but there was obvious reasons for you not being able to live together. But again, it will come down to the actual office that will adjudicate your case. So, Stacy, tell us a little bit about how military service can change the naturalization analysis. Are there any special benefits or expedited pathways that are available to people, to members of the armed forces?
Yeah, so INA sections 328 and 329 are available. Section 328 is peacetime naturalization. And so if you have served honorably for at least 1 year in the Army, Navy, Marine Corps, Air Force, Coast Guard, Space Force, or National Guard, and you apply while you're still in service or within 6 months of separation, you can qualify for exemptions from the continuous residence and physical presence requirements. You still need to demonstrate good moral character for 5 years, not 3 years, but like the spouses of U.S. citizens, but 5 years prior to filing. You still need to be able to pass the English and the civics tests. And keep in mind, the citizenship can be revoked if if as a service member, you're separated under dishonorable conditions before completing 5 years of honorable service. Section 329 is wartime naturalization, and you only need 1 day of honorable service to qualify. And you don't have to have been a lawful permanent resident. If you are physically present in the U.S. or one of the U.S. territories at the time of enlistment, there's no residency or physical presence requirement. Applicants can be of any age. The good moral character is for 1 year. You still need to pass the English and civics tests. And again, your citizenship can be revoked if dishonorably discharged before completing 5 years of honorable service. So if you qualify for 5 years to apply for a naturalization outside of the military service, it's better to get it that way. But if you don't qualify, then the military service is a way to obtain your naturalization. It is expedited for certain individuals, basically those going through active duty or honorable service. And in September 2025, USCIS updated its guidance. Uncharacterized discharges do not meet the requirement under honorable conditions. So you want to make sure that you're able to get the documentation that shows that it was honorable conditions. And they are no longer coordinating with Customs and Border Protection to perform interviews and oaths at ports of entry. There is a special certification that you need in order to benefit from sections 328 or 329. You can file Form N-426 along with your naturalization application, or a DD Form 214. And again, you need to pass English or civics unless you qualify for a waiver, or if you need a reasonable accommodation, you can request that ahead of time.
Stacey, you said that if you qualify under the 5-year rule, better do it that way. So we did have a client who had a green card based on an employment-based green card through his family, because he was a derivative of his family. And it so happens that he did have military service, so he was able to naturalize quicker. And it's such a fortunate thing that he did that, because his family's green card is now in jeopardy for certain reasons. And so because he's naturalized, he's now able to sponsor his family members. So it's a really good idea to explore all of these different venues to naturalize. And the quicker you can, the better it is. So, um, you know, because just in case you have a situation like this where you need to sponsor your family, you have a quicker pathway to do that. Megan, naturalization is often thought of as the final step in the immigration journey. But can you think of a situation where people can actually lose their U.S. citizenship?
Yes, it is possible for someone to lose their citizenship after they've been naturalized. The most common reasons are you procured it illegally, so you were not actually eligible for citizenship at the time. You misrepresented something. You concealed some material evidence. So there's a couple ways it can be done, but one thing to know is that it's historically been extremely rare for this to happen. Very, very rare, although we've seen an uptick in efforts to denaturalize people lately. But it's very rare, and it's also very difficult. So it's usually in civil proceedings before a federal judge. So they do have to take you to court. There's an evidentiary hearing. The government has a very heavy burden in proving that you should have your citizenship taken away. So the courts have held that the loss of U.S. citizenship is a very extraordinary penalty. It's very severe, and it can have severe and unsettling consequences, one court held. So the burden is on the government to show by clear, unequivocal, and convincing evidence. There must be absolutely no doubt about the issue that they're raising to take away naturalization. There's also a criminal ground for procuring naturalization in violation of the law. And if a criminal court does find someone guilty of that, that criminal judge can also revoke the naturalization, the citizenship in that hearing. So the things to take away from it is it's not an easy process. It can happen, but it does have to happen in a court in front of a judge. The burden on the government is very heavy. It's been used rarely, but that may change. And one ground that's interesting that we have seen sometimes, used to be more often than now, if somebody in the 5 years after getting their citizenship takes on membership in a communist party or is involved in subversive groups or anarchist groups, groups like that, they can find that at the time when they when they swore the oath and when they filed their application, they were not really attached to the principles of the Constitution. So they can look at activity that one engages in immediately after naturalizing to show that at the time of naturalizing, they were not really worthy of US citizenship. So there definitely are pitfalls around that. So people still need to be careful, and it can be taken away.
And that's something we've seen ever since the August memo, is that while, we're getting more calls about naturalization, people seem to be hesitant even when they have clean immigration history. There seems to be some concern about how's, the good moral character, looking back into previous immigration history, how is all of that going to impact the naturalization? We have seen, some people want to actually naturalize as quickly as possible, whereas some are more hesitant. And so it will be interesting to see how this continues to play out. But, as we've discussed, there are definitely several benefits to naturalizing. You also have to be cautious when you are going through the process to make sure, again, that you're disclosing everything to your attorney. Because the last thing an attorney needs is to go to your naturalization interview and find out something new that can have an impact on your application process. Stacy and Megan, thank you so much for going over the process, the benefits, the pitfalls. It just goes to show that, for those who do have a little bit of complicated immigration history, that they definitely want to review this with an attorney before they move forward in the process. Again, for those who have no issues at all, you should not hesitate in naturalizing. That would definitely be beneficial to go through the process with an attorney so they can take a deeper dive into your immigration history before you actually file the application. Well, thank you so much, everyone, for joining us today. We hope this has been helpful. We're around if you have any questions, if you want to set up a consultation with us.
Thank you for listening to Statutes of Liberty, an immigration podcast brought to you by Klasko Immigration Law Partners. For more information, visit us at klaskolaw.com. Follow us on LinkedIn, Instagram, and Facebook. You can email your immigration questions to podcast@klaskolaw.com. The materials contained in this podcast does not constitute direct legal advice and is for informational purposes only. An attorney-client relationship is not created by listening to or accessing this podcast. The information provided should never replace informed counsel regarding specific immigration matters.